Good morning, everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So the first thing I want to bring to your attention, so that you are not caught off guard next month, is that effective May 18th, so next month, May 18th, attorneys will no longer be able to appear telephonically for local office interviews. So think your citizenship interviews, your family marriage-based interviews, if you're sponsoring a parent, if you're sponsoring a child, and sometimes employment-based cases are scheduled for interviews in local offices. The Immigration Service very quietly announced last week that they were doing away with telephonic appearances by attorneys. And those really started during COVID, and now they are taking them away again. So as of May 18th, next month, there will be no more appearing telephonically at our local offices for interviews. So just wanted to let you guys know that so that you're not caught off guard next month. The next thing I want to talk to you about is the Birthright Citizenship Presidential Proclamation. As we know, the president, at the very, very beginning of his term, came out with a White House presidential proclamation that essentially ended birthright citizenship. Several lawsuits were filed. We are now at the Supreme Court. Well, the Supreme Court just heard 2 hours of oral arguments on this. So we will see what they say. Some people are saying that, the Supreme Court is not going to support the presidential proclamation. We will see. Probably not going to get a decision. We're kind of thinking we're not going to hear anything from the Supreme Court until at least June. But when we do, I will certainly let you know. But I did want you to know that we are, at least with respect to that particular presidential proclamation at the Supreme Court level, 2 hours of arguments were heard by the justices. And so now we're just waiting on their written decision. Next, I want to talk to you guys about H-1Bs, but not in the way that I normally talk about H-1Bs. So we know that the lottery has been run. We are all we are preparing our H-1B applications to get those in. If you are selected, those have to be in by June 30th. But what I want to talk about with respect to the lottery is an alternative. So a lot of digital ink has been spilled on this issue, myself included. But one of the things that we don't really talk about a lot in terms of an alternative to H-1Bs for some individuals, not all, but for some, is the O-1 extraordinary ability. It can be a viable alternative. So if your employee, or if you are the employee, but if your employee has had significant achievements in the industry with your company and or without, and or before they got to you, has the individual been written about in sort of industry media? Have they been published around what they have been doing? Do they have colleagues who may work with them, or sometimes who've never worked with them but have heard about their work, respect their work? Do they have colleagues in the industry who are willing to write a pretty detailed support letter describing that they know this person's work, that they use this person's work, that they cite this person's work, that they really respect this person's work? Is this person being paid sort of over and above what the average person doing what they would be doing? Are they getting a fairly high salary? So if your answer to the majority of those questions is yes, you may qualify for an O-1 extraordinary ability. And again, extraordinary ability is not for everybody. Everybody does not qualify. It really looks at your past achievements. What have you done for the industry? I like to say, sort of in plain Jane language, are you the best thing since sliced bread in your industry? So So I kind of wanted to sneak that in because I do think there are some people that qualify for an O-1 that just haven't really thought about it because they're super humble and they don't think that what they're doing is by any means extraordinary. They just think they, are doing what they do and they love it and it's their passion. I tend to find that it's those folks that are generally O-1. Meet the O-1 criteria. So if you think that may be you, if you think that may be one of your employees, we're certainly happy to have a conversation with you about it. And the last thing I wanted to mention, that I've answered one question last week about it, and I thought, I haven't really talked about this in a while. If you have an active case with USCIS, then you have moved, you've changed your residence, you need to tell CIS that you've changed your residence. It is a requirement. You can either go online, there's a form that you can fill out online on the USCIS website, or you can change your address. You can notify them of your address change through your My USCIS account. You do not need a My USCIS account to do it online, but if you have one, you can certainly do it through your My USCIS account. So I got that question last week, so I wanted to kind of bring that up to folks just in case. So if you have any questions about whether or not you need to change your address, whether or not you qualify for an O-1, if you need assistance filing your H-1B cap case before June 30th, reach out, let us know. We're happy to help you. And that's all I have for you this Monday morning. So have a great rest of your Monday and a fantastic rest of